Okay, so in today's webinar, we're going to talk about patents, and this is related to an ongoing series of brand protection masterclasses brought to you by LegalVision. My name is Linda Hartman, and I'm the patent practice leader here at LegalVision. So I help all kinds of businesses, from startups to established businesses, to develop and protect their intellectual property. Now, LegalVision is a tech-driven, full-service law firm that uses technology to deliver a faster and more cost-effective client experience. We were recently named the fastest growing law firm in the Asia Pacific by the Financial Times. In this webinar, we're going to cover off some of the basics of IP protection, specifically in relation to patents. We'll cover off some points about why it can be useful to protect your intellectual property in a patent, as well as some details on what you can and can't get patent protection for, and also what rights a patent affords you. We'll then discuss the patent pathway and provide some insight as to how you go from having a patent application, where you can use the terminology patent pending, to having a granted patent that you can actually enforce. The webinar will culminate in some very practical advice about common pitfalls associated with patent protection strategies and ways of avoiding them. So why are patents important for your business strategy? When it comes to patents, the obvious answer as to why you'd bother seeking protection for your invention is so that other people can't copy or use it. It's pretty simple. But the benefits of having a patent or patent application encompassing your invention are far more reaching than that. Firstly, a patent or patent application is an asset to your business that has a value, and this can be sold or licensed or used to expand in overseas markets. A patent application is a really convenient way of packaging your intellectual property that clearly defines the scope of the invention. And selling the IP associated with the business can also enable a really nice, clean exit strategy, if that's what you're after. Strategically, patent applications can be very attractive to potential investors who may want to invest in your company but need some evidence that you have protection in place. Investors may be reluctant to invest in a company if they think the driving force behind that company can be easily copied by a rival. Similarly, if you're applying for government grants, sometimes there will be requirements that you demonstrate you are seeking protection for your IP so that you'll have an exclusive right to it. Lastly, even if you don't end up getting a granted patent, a patent application and the corresponding patent pending terminology it allows you to utilize can be an effective deterrent to your competitors who may not want to enter into your market space for fear of enforcement and damages down the track. Now, what is a patent? It's a good question. A patent is a tangible stationary document that provides an intangible legal right. It's a somewhat confusing concept to explain sometimes, as a patent and the corresponding document captures dynamic subject matter, namely an invention. The patent document, or patent specification as we'd call it, must provide a full disclosure of the invention and define an invention in terms of its essential features. What is required to make that invention work? And these can be physical or functional features. We'll discuss the reasoning behind this a little bit more later. Now, an invention that can be patented is any invention with a useful purpose, and this includes anything from compositions, methods of treatment or surgery or diagnosis, production processes, machines, tools, even new plant species or engineered microbes. As patent attorneys, we need to define an invention in terms that create a wide boundary around that central inventive concept to your invention. Otherwise, the right can be pretty worthless and can easily be circumvented. So if you think of the invention you've developed and wish to commercialize as the flag that you planted, think of the patent document as a means of placing a fence around your invention. But all of the versions of your invention that fall within the scope of that fence need to work at least a little bit. They don't have to be perfect, just at least work. In a first instance, when we draft a patent document, we make this fence as wide as possible, though it may be reined in a bit during the process of getting a patent application granted. So, keeping in mind our flag and fence analogy, let's consider this in the context of one of the most famous inventions in recent history, the Humberts Post-it note. Now, this is a great example of an invention being defined by both functional and physical means. The Post-it note is primarily protected by a patent that describes the glue used. but the glue is not defined by a specific composition. That would be quite limiting and allow competitors to get around the patent by simply changing the glue. It's defined functionally as well. This is particularly relevant in view of all patents having a 20-year term. Whilst the glue used when the post-it notes were first developed might have been quite specific, assuming that there would not be technological advances in glue manufacturing compositions in 20 years would be really foolish, and you could lose protection on that basis. So what do you get from a patent? Now, this is that intangible right. The intangible right associated with the patent is an exclusive negative right to exploit the invention captured by the patent. And this right generally lasts for 20 years from the date of filing the complete patent application. By exploit is meant to make or sell or use or do or import or export. And the negative right is there to prevent someone else from doing any of those things. You don't actually have to do those things yourself. Also, an exclusive right to allow someone else to do something, in that you can give someone permission to exploit your patent. The patent right that you get is a property, and it can be traded, licensed, or even made open use if you choose. A patent right also only applies to the patent area that the patent is granted in, and generally this is an individual country. So every country has its own patent office and its own patent law, and if you want patent protection in a particular country, then you have to seek a patent in each individual country. There is no such thing as an international patent. There is an international patent application, but that's not an enforceable right. Also, when it comes to inventions that are captured in patents, it only matters if you're the first to file a patent application for that invention. Essentially, patent offices around the world don't actually care who invented something first. All they care about is who filed a patent application first. This is commonly referred to as the first to file law. So what do you need to do to go from being a patent application to a granted patent? So let's be clear, a patent application is not an enforceable right. You can only sue someone off the back of a granted patent. Anyone can throw anything on a piece of paper and file a patent application and use the term patent pending as a deterrent. However, for a patent application to progress to being a granted patent and be enforceable, it must pass examination, and the requirements that need to be met are set out in law and facilitated by patent examiners working in patent offices around the world. The laws are a little bit different in each country, but there are some basics that are common to everyone. So the requirements can, to a certain extent, be grouped into two different categories. There are laws that relate to the invention itself and laws that relate to the physical document or that patent specification you submit with the patent office to claim your invention. Now, the invention commonly must be useful, as we've described, novel and inventive, and it also can't be a business method. You can't patent ideas and discoveries, and in terms of novelty and inventive step, your invention will be compared against the prior art by patent examiners during that examination phase, who will consider how new your invention is in view of this prior art. Now, prior art essentially just means any publicly available information before the date you file your patent application. And this can be in any language, anywhere in the world. There's no geographical restrictions. It can also include information that you have put out in the public domain yourself about your own invention. This is why you shouldn't disclose your invention before you file a patent application. In regards to the document that you file for your patent application, this must include a clear and complete disclosure of your invention. That is where the quid pro quo comes into play in terms of patent law, in that you are fully disclosing your invention to the government and also to the public in exchange for an exclusive patent right. The disclosure must be sufficient for someone who's skilled in the art to be able to perform at least a working version of your invention. The invention must also be exemplified with some sort of proof of concept. The legal term is the best method, and that just means that you disclose the best method you have of performing or making the invention at the time of that initial filing date. It doesn't have to be the version of the invention you end up commercializing. This requirement also prevents you from getting patent protection for just an idea. You need to prove to the Patent Office that your invention is real and that it works. So patent prosecution. What is patent prosecution? So this is the term that we as patent attorneys use to describe the process that you must go through from having a patent application to a granted patent. Effectively, you're prosecuting the patent application. But there are many, many pathways you can follow to achieve the same result. And the pathway will vary depending on the nature of your invention, the countries you want protection in, and time or money considerations and constraints. But in general, the patent application will be examined by a trained patent examiner in the relevant patent office to determine if the application meets the requirements of both the document and the invention before you can get it to grant. The law, as well as the procedural requirements and timelines and deadlines, will vary in different countries, but you are afforded a right of reply when examination reports issue. You can argue against what the examiner has said and the prior art that might have been raised, as well as even amend your claims to adjust the boundaries of that fence and perhaps narrow the scope of your invention that you're asking protection for, so that it no longer overlaps with things that might have been already disclosed in the prior art. So as mentioned, there are many pathways you can travel down to get a granted patent. But one of the most conventional is to utilise the PCT system. So PCT is the Patent Cooperation Treaty. So the PCT system to help stagger costs and also provide more time before you need to make big and often expensive decisions about the countries in which you want to file individual patent applications. The first step in almost all patent pathways is, and really should be, the filing of a provisional patent application. This secures your priority date, which is the date that you start excluding prior art, but it doesn't actually start that 20-year clock ticking. So you're kind of getting a bit of a year free. It's important to file a provisional application as early as possible, but it does require some proof of concept. The provisional application isn't published and it expires in 12 months. And during this 12 months, you can add data to support your invention as you develop it, and decide during that 12 months if you want to actually pursue the patent application. If you don't, the provisional application effectively disappears, but you do lose your place in that queue, so you do lose that earlier priority date. At the 12-month stage, you can convert the provisional, perhaps after refining and adding support and data to the application if you want, to a PCT application, and this serves as your international placeholder, generally for another 1.5 years, depending on the timing. During this time, you can utilise it to raise extra funds for the next stages. Compulsory examination occurs at this international stage, at which point you can respond to the international examination report, but you actually don't have to. So you can have 1.5 years of nothing really to do and no additional costs after filing that PCT application. You can use the PCT application as a jumping off point for filing all of your desired countries down the track, well, almost all if you exclude a few exceptions. And then these go through examination individually before those individual patent offices we were talking about. The interesting part about this is because patent law differs in the individual countries, you can end up with slightly different patents granted in each country depending on the law. There are also lots of different fees and deadlines for each individual patent application. And then after even a patent is granted, you will have to pay renewal payments for the granted patents before the different patent offices. However, if you're interested in Australia only, you can go straight into an Australian standard patent application from a provisional application. If we were to focus on the specific case of getting a granted Australian patent, despite the route that you may take to get the standard patent application filed, you still end up in the same place. You will be directed by the Australian Patent Office to request examination, and that you do get pushed into the corner eventually. And you must, once given this direction, request examination within 2 months, or the application will actually lapse. So you can't have patent pending with a patent application forever. Eventually, every standard patent application needs to be examined to be granted, and if it fails examination, it will actually lapse. So once you request examination, an examination report will issue. So in this report, the examiner will raise relevant prior art and will make comments as to how they believe your patent application does or doesn't meet the patent requirements. So and those requirements are related to your invention and also the document as described previously. After this first report issues, you actually have a right of reply for 12 months, and you can go through multiple cycles in this 12 months where you can respond and then another report issues. It can effectively be an infinite cycle. But eventually, the Patent Office does need to be satisfied that the claims at the back of your patent application encompass a patentable invention, so that you have an invention that is both novel and inventive and supported, and the document has a clear and complete disclosure and best method. All of those requirements need to be met. Because of all these requirements, you can obviously fail to get through the examination process. And this generally is the end. I mean, there are other ways that you can keep patent pending going through divisional filings, but you can't refile indefinitely and you can't have re-examination indefinitely. But you can seek to go through the process of division applications. And this is a different strategy, but you may want to see how the law changes or what your commercial embodiment is in terms of getting an invention re-examined. So before a patent application is granted, it has to go through an acceptance phase, but this isn't actually grant. There's still one more hurdle to overcome, which is common to most jurisdictions, though the details of this particular period may vary. In Australia specifically, an accepted application is laid open to be opposed. This is the opposition period, what we call. That is, the notion that the patent is to be granted is opened up to third parties, any third party, to allow those people to make official submissions to the Patent Office that the Patent Office actually got it wrong and the patent shouldn't be granted. These third parties, in their submissions, they can raise new prior art or evidence or new arguments about the law and or interpretations to argue that that accepted patent application shouldn't proceed to grant. If this happens, which admittedly is rare, there is an opposition process. This can be quite expensive and time consuming, but if there is a particular accepted patent application that you don't want going to grant for your own commercial reasons, opposing it at this stage is much cheaper than going through the court system after the patent has actually successfully been granted. Eventually, all things going well, after a patent is granted, renewal fees are going to be payable for that 20-year term, and the patentee also has an obligation to keep the patent register up to date. So things like details of if it's been licensed can be amended in the patent register, if there's been a change of ownership, that sort of thing. So there's a lot of pitfalls that can be met during the patenting process because it can be quite long and complicated. And unfortunately, most of these pitfalls we've seen quite routinely with small businesses and innovators. Now, self-disclosure is a really big problem, especially now in the age of the internet. So conference abstracts now end up being published. Demos go onto YouTube, and selling your invention is out in the public domain for everyone to see. These disclosures, even by yourself, are now prior art. There's this common perception, and really a misconception, that grace periods are always going to save you from these self-disclosures. But it's important to note that this isn't going to apply to designs, and grace periods are only available for set periods of time, such as 12 months or 6 months, and they're not available in all patent jurisdictions, such as Europe. They also open the door for intervening rights. Secondly, please don't draft your own patent application. Once a patent application, that physical document that wraps up your invention, once it gets past a certain point, we can't actually fix it. So a patent attorney can't step in and fix your application. And you will almost certainly fail the examination process associated with that patent document, those requirements that you need to meet. Remember, you're being examined on that document as well. Patent attorneys, in addition to having pre-approved scientific qualifications, must do a full law master's just in IP and a 2-year apprenticeship as a patent attorney to learn how to convert an invention into a legally binding language required for a patent application. So it's not a simple undertaking, and it's better to engage and get professional assistance for that. Also, in terms of IP costs, yes, they can be high, the process can be drawn out, but think about who's going to pay for your IP costs, because it doesn't actually have to be you. For example, if you're looking at licensing deals for your invention, perhaps you can wrap up the IP costs in that licensing deal so that the person who's getting the most benefit out of your invention, i.e. the person exploiting it, is actually paying for those IP costs. Also, international markets. So people often underestimate their market, and they miss the window for filing in multiple countries by not looking to the future. Once a window is closed, it's done. For example, you might think your main jurisdiction is Australia because that's where you're making your product, but only having a patent protection in Australia won't stop someone from making it and selling it in the US or even exporting it to Europe. So you need to think about where you actually want your product protected, especially in such a global marketplace today. So lastly, top tip, make sure it's clear from the beginning who is an inventor and who owns the rights to an invention. An inventor is not necessarily the owner of an invention, depending on contractual obligations or assignments. Unfortunately, these things tend to only become issues when folks start making money and people want to contest inventorship or ownership. And this can actually open up your patent for susceptibility to revocation, even if ownership and inventorship is not clear and there's not a clear chain of entitlement for who owns that invention. So that's our pitfalls section. I think the takeaways from today is that IP protection, it's an important part of your business strategy, even if it's there as a deterrent and not necessarily an enforceable right, or even if it's there to be an asset that you can trade or something to actually gain leverage from. IP is important for your business strategy. Next thing is that you need to remember that it's not just your invention that gets examined during the patent processing, it's also the document. So unfortunately, you can have the most amazing invention with a truly novel idea, and if it's not captured appropriately in that document, you may never get granted patent protection. You may never be able to enforce your rights for that brilliant idea. And also, obviously getting a patent application to a granted patent can be a lengthy process, and it can be an expensive process, and it does require patience. And also it's going to be greatly assisted by some professional assistance from your local patent attorney, preferably at LegalVision. So that's it for us today. Hopefully everyone got something useful out of that webinar. And if you have further questions, you can follow us up at LegalVision.